One, it's useful to remember the Constitution itself allows the President of the United States to suspend habeas corpus. Abraham Lincoln did it during the Civil War for kind of obvious reasons. Now, by the way, Lincoln extended it to places that it didn't belong. So, for example, Lincoln extended the suspension of the writ of habeas corpus to parts of the country that were not in the middle of a conflict. So he could dispatch certain critics and others that he didn't like. So that was a part of Lincoln's legacy. That's not the better part of his legacy. But it is useful to remember that in case of invasion, and that's what the president has already determined here under the Alien Enemies Act, that there's been an invasion, particularly of TVA gang members, on behalf of a state-sponsored invasion by the Venezuelan government as payback and punishment for sanctions on Venezuela, and to relieve their massive crime problem in the then upcoming election in Venezuela. They needed that radically reduced. So how did they do it? They gave basically free mechanisms and means and in collusion with Soros-sponsored NGOs to flood America with some of the most dangerous gang members in the world. That's who Trump is trying to correct and fix and remedy. The Supreme Court, up until this point, had constantly said that even in the context of a habeas petition, that relief is very limited. That essentially, that the only thing you're looking at is whether a person's in U.S. custody, is whether an executive official gave him due process. And what does that mean? Did they ask some questions? Did they do? I mean, it's real basic. They said it can be summary. They said it could be in a 2-minute hearing, right? So that gives you when you're not here legally, you have very little constitutional interest against deportation. That's what the courts have said forever. And now this happened even with people who are here legally. This happened in all the first set of cases all include the Chinese Exclusion Act cases. So from 1886 to 1915 or so, you've got a bunch, and with all kinds of eclectic sounding Chinese names, like Wing Wong and Ying Yu and all the rest. You need to pronounce Mandarin to get it right, and Mandarin's an important language to pronounce because the same word can sound totally different based on your pronunciation. Either you're saying I want some soup, or you want the kind of soup that ends up in the toilet. So all depending on how you phrase the word. But that's been the law until this past weekend, where the Supreme Court overturned and ignored over a century of legal precedents that said the executive branch completely controls the borders and foreign policy and immigration. That Congress completely controls what due process they allow. And they didn't allow the courts to be involved in this process much at all if they're illegally here in the first place. And that due process does not require anything more than a very summary executive official proceeding for that person to be removed from the country. They just ignored it all in issuing an insane injunction that wasn't even procedurally proper. I mean, what happened is after they said you have to bring individual habeas cases and you have to bring it in the jurisdiction where the person is detained, and habeas is extremely limited as to what it's required, and doesn't require anything more than the court to just say, yes, he got his executive due process, that's it. What the habeas is there for the person that is truly being mistakenly removed. In other words, someone who's legally present, who, for example, say wasn't a communist, as was in some of the communist deportation cases. Because the first group, Chinese exclusion cases, second group, communist exclusion cases. Read the breadth of the law in those cases. The Supreme Court said many times said, quote, there is no place for judicial review. Supreme Court has said this repeatedly for a century and a half.
What you just heard was Robert Barnes, a constitutional lawyer, explaining why he believes President Trump had the authority to deport Kilmar Abrego Garcia without a trial, without a hearing, and without following a single court order. He said it calmly, as if it were just a fact of life on Easter weekend. And now we need to unpack what that means. Not with memes, not with vibes, with the Constitution, with history, with law. Because what Barnes is defending isn't immigration enforcement. It's executive supremacy. And if you believe in due process, this is where you draw the line. First, let's start with the most basic question. What is habeas corpus? The phrase is Latin. It means you shall have the body. In law, it means that if the government is holding you or has done something to you like exile or detention, you have the right to be brought before a judge. It's how the legal system proves it's still a system. You don't disappear people in a free country. You make the case. Habeas is written directly into the U.S. Constitution in Article 1, Section 9. That's where it says that the right to habeas corpus can only be suspended in cases of rebellion or invasion when public safety may require it. In other words, it's a constitutional emergency valve. It's not normal, it's not easy, and it's not something the president gets to do on his own. But Barnes said the opposite. He said the Constitution allows the president to suspend habeas, and he meant it. He argued that Trump already declared an invasion, and that this declaration gave him the power to bypass the courts entirely. He said this wasn't just legal, it was constitutional. That is false, and it's dangerous. The suspension clause is in Article 1 of the Constitution, not Article 2. That means Congress controls it, not the president. In fact, the first time this issue ever came up was during the Civil War. President Abraham Lincoln tried to suspend habeas corpus on his own, but in the case Ex Parte Merryman, Chief Justice Roger Taney ruled that Lincoln's suspension was unconstitutional. Only Congress, he said, could suspend the writ. Lincoln ignored the ruling at the time, but he didn't pretend it was legitimate forever. Eventually, he went to Congress and got a law passed in 1863 to authorize the suspension. In other words, even Lincoln had to admit that the president doesn't get to do this alone. And since then, no president has been allowed to suspend habeas on his own. Not Roosevelt, not Bush, not Obama, not Trump. The Supreme Court in Boumediene versus Bush made this even clearer in 2008. That case said that even non-citizen detainees held at Guantanamo Bay on an offshore military base still had habeas rights. The court ruled that Congress had tried to remove those rights without formally suspending them, and that doing so was unconstitutional. The ruling didn't just protect detainees, it reasserted that habeas corpus is the baseline, and suspension is the exception. So when Barnes says Trump can declare an invasion and strip people of that right, he's contradicting more than 200 years of constitutional law. But he doesn't stop there. He uses Lincoln as his example. He says Lincoln extended the suspension to critics and areas not in conflict. That was not the better part of his legacy, but that's not a caution, that's a shrug. He acknowledges that Lincoln used the power abusively and then immediately sets up Trump to do the same. There is no skepticism, no concern, no warning about what happens when you tell a president he can ignore the judiciary. Instead, Barnes positions it like a historical playbook, and then he brings in the Alien Enemies Act. That's an old law from 1798. It says that if the United States is at war or facing an invasion by a foreign government, the president can remove or detain enemy nationals who are on U.S. soil. Trump did invoke this law in March 2025, but only for Venezuelan nationals affiliated with a gang called Tren de Aragua. Kilmar is not Venezuelan. He's Salvadoran. He was not included in that proclamation. And in court, the DOJ never once claimed the Alien Enemies Act gave them the right to deport him. Instead, they said it was an administrative error. That's a quote from their own filings. So Barnes is defending a legal theory that wasn't even used. He's retrofitting war powers to a case where the government already admitted it broke the law. He's presenting defiance as doctrine, and that brings us to Kilmar himself. In 2019, an immigration judge ruled that Kilmar could not be deported to El Salvador. That protection is called withholding of removal. It means the government must leave you alone, because if they send you back, you're likely to be killed or tortured. That's not an opinion, it's a court order. But in March 2025, ICE agents grabbed him off the street, didn't reopen his case, didn't give him a hearing, and put him on a plane. That's not policy, that's lawlessness. And every level of the judiciary agreed. The district court ordered the government to bring him back. The appeals court upheld that ruling. The Supreme Court ruled 9-0 that the deportation was unlawful. That's not just one judge, that's every judge. And not one of them said, the president can do this if he declares an invasion, because he can't. So how does Barnes deal with that? He says Kilmar had no due process right at all. He says people like him get a 2-minute hearing. He says deportation isn't punishment, so the Constitution doesn't apply. That's wrong on every level. The Supreme Court in Zadvitas versus Davis said clearly, the Due Process Clause applies to all persons in the United States, regardless of status. That means you can't just jail or deport someone without notice, without a chance to respond, without a lawful order. Kilmar had all of that, and the government still broke the law. And what makes it worse is that the government had legal options. If they believed Kilmar was part of MS-13, they could have filed a motion to reopen his case. They could have submitted new evidence. They could have asked the court to revoke his protection, but they didn't. They skipped all of it. They deported him first and then tried to explain it later. Even the DOJ attorney in court couldn't say what legal authority had been used because there wasn't any. And let's be clear, no court has ever upheld this logic, not in World War II, not after September 11th, not during COVID. No court has said the president can deport someone with a standing protection order by calling it an invasion. The only people who say that are on YouTube. And that brings us to the ecosystem behind this narrative. Barnes has business interests with Rumble. He's helped shape their moderation policy. He defends Peter Thiel, the billionaire founder of Palantir, an early Facebook investor, despite Thiel's ties to surveillance, military AI, and the World Economic Forum. Barnes has attacked James Corbett, Nick Fuentes, and other dissidents. He's not doing this as a neutral lawyer. He's doing it as a figure embedded in the parallel economy. And when you look at the content of his arguments, it's not law, it's legal cosplay, a fantasy of unchecked power. The lawyer's version of executive fan fiction where the president can override every court and deport anyone by decree. And what that means for you is simple. If this theory wins, the Constitution loses. If the president can bypass the courts by calling you a threat, then there's no law, only orders. Kilmar had due process, he had legal status, he had a judge's protection, and the government ignored it. That's not constitutional authority, that's a rogue executive branch, and every court said so. Barnes is arguing against every judge who looked at the facts, and that tells you everything you need to know. Because what he's defending isn't conservative. It's not legal. It's the end of habeas corpus, the end of judicial review, the end of restraint, and the fact that it was said on Easter by a man quoting scripture makes it all the more horrifying. If you care about law, you reject this. If you care about the country, you condemn it. Because if it can happen to Kilmar, it can happen to anyone, including you. And they won't even need a judge to say so. Just a tweet, just a label, just a flight, and then you're gone. You have the facts, the rulings, the precedent, the procedure, the recent history, the constitutional text, and the judiciary on your side. What Barnes said wasn't just legally wrong, it was deeply authoritarian, historically tone-deaf, and factually discredited. You can call it legal cosplay. A fantasy of unchecked power. The lawyer's version of executive fan fiction, because that's what it is. And it's not just dangerous, it's an invitation to dismantle everything we say we believe about the Constitution. This case is where the line was drawn. And if you don't stand on it now, don't be surprised when it disappears.